Oh, the one you built, it was by the water, right? It could be that, because I don't remember if it was the water, if it was like any water around though, but I do know it was mad cold in the summertime. Well, I guess maybe it was.
There's another
Have you
one called
guys
Grant Park.
Grand Park? Let me see that.
Grant Park. That one's, they throw concerts there too.
Grant Park, like Grant, right?
Yes. Yes.
Let me see. This is crazy. I don't know why Obama and Michelle just popped up right now. Also awkward. Okay, let's see. Do you know the address by any chance?
Well, let's see. It's Randolph and Michigan. Type in
Let me see.
Michigan Avenue and Randolph. Probably 300 south, 3 or 400 south, Michigan.
I think it's over here, 300 South. Well,
Hey guys, we're standing by for Glenn to come in.
Cool.
you said Grant, like Grant Cardone, or this is a different Grant?
With a T, Grant. Grant. You know, like
No, I
Grant
think somebody
Stan.
said. No, not you. I was talking about somebody said that we're standing by for Grant to come in or something.
No, Glenn.
That's right.
Glenn
Oh,
Fern?
Glenn.
Yes.
Oh,
Yes.
okay.
Yes, he
Okay.
could be showing up possibly any moment. Just wanted to let you guys know.
Okay. And by the way, Mary, you was right. It is Grant Park.
Cool. Yeah, I think it's called Pritzker Pavilion. They changed it so many times. Now they call it Pritzker. I don't know. I don't like that man. That's our governor. He's dirty. Dirty.
Sorry, I couldn't hear what you just said.
I think it's called the Pritzker Pavilion now. I don't know. They have concerts. They have really nice symphonies. Back in the day, you know, they would have like Taste of Chicago and a thing called Chicago Fest and, you know, little, you know, I don't know. I remember like the Jets. Let's see. I forget what their songs were, but I remember I saw them. Really famous free concerts, famous bands, you know, from like when I started going, it was in the 80s, you know, so I don't know. All that like 1985 little bebop music. My big sister would take me, you know. It was a treat, you know, see some famous people and you know, I'm not into that now. I'm not into the crowds. I'm not into any of it. Especially now. It's really changed. It's people are getting mugged. A lot of people are just rob you in broad daylight and they don't care if there's cameras or anything. So I like to stay in my little neck of the woods where, you know, the crime is not so bad. There's like zero homicides over here, you know. So it's
Great.
quiet over here.
Yeah, I stopped being into all of that crowd stuff too. I used to be into that, but yeah, life changes and things are just getting worse. We the people, we need to start standing up and actually making a change for the community. I feel like a lot of these crime rates are high because um people don't really have much. They need arcades and other opportunities and getting their mind out of the hood. Sort of like a ball player's dreams. They want to do it all to be successful. Now, what if you was to start a program where you can actually lead them down that path? They won't be mugging nobody, right?
That's right. See, I was already thinking about that. When I go and take that DCFS building, how it's called a single family home, I don't know, it's tax fraud. I need a big wrecking ball. And I was thinking, well, I definitely would like to have a really inexpensive laundromat and have that money go back into that community. It's in a really, dilapidated area. And a healthy grocery store right next door, and an arcade, maybe a pool hall, maybe taekwondo or jujitsu or some kind of I don't know, some kind of self-defense. I don't know,
Right.
dance studio. There's so much that our children are lacking. Maybe music for teaching. I don't know, because I've got to make this 501c3 corporation out of that spot. So that company cannot ever do that to our communities and our children. And it's all about the trust. It's all about banking on our Social Security. And people don't even realize it's not about the child. They took my child without even any kind of investigation. They put me in jail. A judge told me I had a warrant. She lied. Ooh, she's in a lot of trouble. And then I found out. I started looking. Where do they get their rules from? What is the procedure? What is it that they have? Who tells a judge she's got a warrant? Oh, that would be the state's prosecuting attorney. Oh, I was her witness. So then, what's the protocol? What's the procedure? What's the administrative procedure? Well, the judge would tell the clerk, "Hey, clerk, we got the bad guy in jail." She said I had an. She said she didn't. It wasn't her warrant. It was another judge's, and I knew it was all baloney sausage. So the clerk, it's called collusion now, because now the clerk said, "Oh, hey, judge, we don't have anything in the system here. I'm updating this existing warrant and none appears." So they're all complacent. And so then the sheriff comes and arrests me out of court and puts me in the jail. Now it's the sheriff's job to call the DA at the federal district. We got the bad guy. She's in our little lockup holding facility. Okay, entered into the system. Federal. There's federal charges they charge me with too. They charge me with abducting my own offspring. Pretty hard
Wow.
to do. Yeah, pretty hard to do when there's no one I'm fighting as far as anybody else on the birth certificate. Oh,
That's
yeah.
ridiculous, man.
Uh-huh. It wasn't like I was holding her from daddy's visitation or something. No. So all of it. And then
Hey, did you do your power of attorney? Sorry, I don't mean to cut you off, but did you do a POA for her?
I'm in the process of doing that right now. Yeah.
Good. Please do that immediately. Even though they don't have the right, you just want to have those things in line so nobody can tell you anything. You know, just like with me, these assholes charged me for Grand Theft Auto with my own car.
Like,
For my own car, they threw the case out. So Yeah, I actually been dragging my feet on that case. I need to sue their ass because I'm like, I already have 9 judges in default judgment, the district attorney, and the whole criminal clerk's office. I'm like, damn, should I ease up on them? No.
No. How long ago? Because you could only sue the cops for official misconduct for 6 months. Even though it's 2 years for criminal, you can only sue the cop for, you know, for what's it called? It's
Cop?
a police officer. Yeah, 6 months you
No,
have
you
for.
that's don't believe that system. It's not true. You can
Okay,
come back whenever you like. It's sort of like abandoned property. Once you have a default on them, you can come back in any time.
because
There's no statute of limitation on it.
fraud. Yeah, but this is like
What
official
happened to
police,
you?
like overextending her power. What is it called? I forget now. But for
Officious?
yeah.
I love that. I love when they act like that. Why? Because I just hit them with a warrant. It's like putting a warrant on them.
And then make sure that once you go to federal, you can stop them from ever holding public office ever again. That they'll never serve in that capacity. They'll be lucky to pick up elephant poop. you know, Make them making license plates for a while, that's for sure. But when they get out in, I don't know, 10 years, 15 years, some of the crimes I was looking could be up to 20 years for, just lying. A judge
Right.
lying is very serious. But a police
Treason.
officer, yeah, because that's her. There's no higher authority than a cop and than a judge in her own courtroom, you know. So even though I knew she was lying to me, I didn't want to make it stink because if I did, then she could really charge me for, for what's that called when you disrespect the
Contempt.
judge? Contempt, yeah. And that would have stuck. So I was like, oh, I said, I don't understand.
Don't
I don't
believe it. Not
understand.
to
I
cut
don't
you
have a
off.
warrant.
Hey, sorry to talk on top of you. I was like, don't believe that. That shit don't stick. It does not stick. They're in contempt because they have been, committing treason forever. Yep. So I questioned them. I actually set out an order to them. And if they do not answer and acquiesce, they are in default. Judges don't even have that much power. They're actually all just administrative clerks. All clerks. So, don't let them trick you with that black robe on. They're all clerks. They have no power. And I forgot who it was. Somebody was talking about something on TikTok told Donald Trump to open up those concentration camps. They're finna send a lot of people right now in them concentration camps. And I'm talking about judges, lawyers, and other administrative clerks. So yeah, it's getting better. President Trump.
Okay, I sent you both the constitutional. It's the same video. One had the the motion in there. What is it? It's called. And if you could share that, I can't share on the wall. It says, using what your court's procedures allow, following is an example of text to try. But this is only a test. And then proper name of the court and the defendant, notice of constitutional question. And it goes, whereas the third section of the sixth article of the Constitution of the United States mandates, this says the senator, states that the senators and the representatives before mentioned, and the members of several state legislatures, and all the executive and judicial officers, both of the United States and of the several states, shall be bound by the oath or affirmation to support this Constitution, but no religious test shall ever be required. Ooh, that just reminds me. In their paperwork, before this man stamped his little rubber stamp and signed and swore that, this is true and to the best of what he believes, he praised at the court. Now, that's a prayer. That's not a testimony. That's a prayer. And I'm going to get him for that. What is this, a fucking prayer? Or
He said he prays.
he
That's crazy.
prays. He
So guys,
prays.
hey Mary, our guest speaker has come to the mic, so thank you for bringing all that info forward. Glenn's here. How's it going tonight, Glenn?
I'm doing well. I am a bit late. I apologize. But that was interesting what they were talking about previously about prayers. I know there's other people that do that, but that's, I don't know, my attitude, what slaves do. They beg. And in my motions, what I do is this is what I require. Respectfully, of course, but I think this judge is sympathetic in my case, and so we'll see, I guess.
Yeah, exactly. You've got a judge that seems to be working with you, so maybe she's saying a prayer on her end.
Well, you never know. I basically tell him that he works for me, and because I'm posterity. Will Livingston's my fourth great uncle, and so he's working with my authority, and actually. I tell him that he doesn't have any authority over me and that I want him to do his job to regulate his property under Article 4, Section 3, Clause 2. And
excuse me. Let's restart the recording because there's been a lot of lapses and, just to
I'm going to do that right now. So
I'm sorry to interrupt you, Sir Glenn.
No, that's okay, Mary. We're going to read the Bivens as soon as Glenn's finished with that one statement. He knows the entrance of how we usually start it. So, but thanks for the reminder.
And that's a good reminder. I appreciate it. Yeah, let's go ahead and get it recorded. So we'll do the Bivens, and then we can record it, and then everything I say is going to be recorded.
Good idea. Okay, I'm going to pull that up, and I'm going to change the name of the title as I'm reading that Bivens. Okay, here we go. Okay, here we go. This meeting is private. Bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, county, or city or township agency present? This is also for the notary, poll worker, school board member, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Second time, this meeting is private. Bearing false witness, misrepresentation, posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in tonight's meeting that is a member of or agent of any law enforcement agency of a federal, state, county, or township agency present? This is also for notary, poll workers, school board members, anybody who has signed an oath to the de facto government. Okay, and last time, here we go. This meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agencies of a federal, state, county, or city township agency present? And this is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Looks like we're all clear, so here we go. Go ahead. Change the recording title right now.
All right. Well, let me share. I've got a couple Word documents I've got open. This is actually a motion. They went and did the Texas Attorney General filed a motion to dismiss because I'm suing the Chief Judge of the Supreme Court. And so this is my response. Matter of fact, it's probably kind of hard to read, so let's see if I can't make it bigger so it's easier to read. How's that? Is that easier to read?
Good. Yeah, that's great. That looks awesome.
Okay. So motion to deny, Texas Attorney, motion to dismiss, and motion to strike. So I want to get the court to strike their motion to dismiss, and motion to dismiss and to strike the text comes now the demandant moving the county. See, I went and it's we the people. So comes now demandants moving the court to deny the Texas Attorney General motion to dismiss and to strike the Texas Attorney General motion to dismiss because he ceased to represent the government. An officer who acts in violation of the Constitution ceases to represent the government. Officers of the court have no immunity when violating a constitutional right, for they are deemed to know the law. And no state legislator or executive or judicial officer can war against the Constitution without violating his undertaking to support it. The constitutional theory is that we, the people, are the sovereigns. The state federal officials only are agents. The Texas Attorney General is attempting to represent Hecht, who is being sued in his private capacity, has stated that the following, which the demandant will handle as separate items in a brief attached. The demandant's a sovereign citizen. The demandant is very saddened by the Texas Attorney General behavior and cannot believe they're representing the state of Texas Municipal Corporation or its parent corporation, the United States, which is domiciled in the District of Columbia, and can only be making some of these statements in their private capacity because the United States cannot commit treason. The Texas Attorney General has called the demandant a sovereign citizen like it was some sort of a bad thing in what appears to be an attempt to slander the demandant with name-calling. It also looks like the Texas Attorney General and Hecht are engaged in war crimes by taking reprisals against the demandant for his political beliefs in support of the Communist Chinese. It appears they're giving aid and comfort to the Communist Chinese who are currently in power in the District of Columbia, and the demandant is not too surprised at these bar members perjuring their oaths and engaging in felonies with apparent impunity and misappropriating public funds and participating with their targeted justice, as evidenced by the targetedjustice.com website. And I don't know if anybody's seen that website, but I think I talked about it last time, but I'm not sure. But this is This is a website that talks about how the FBI has been in a program of basically people that are targeted. They refuse to prosecute felonies against them or even investigate felonies committed against them. And the U.S. attorney refuses to prosecute them, which is really the subject of another lawsuit and goes to the Cloward-Piven strategy discussed in the First Amendment demanded for relief, and is to be continued in the brief attached. Demandant lacks standing against Hecht. This is what they're claiming. Hecht has sovereign immunity under the 11th Amendment. Hecht has judicial immunity. Hecht has qualified immunity, and failure to state a claim upon which relief can be granted. And then the requirement. And so I don't pray, I require. Demandant moves this court to deny the Texas Attorney General's motion to dismiss and to strike it because he has no standing to represent Hecht. Respectfully submitted, sign and seal of red ink on the land under penalty of perjury. Yeah, this is my standard. And I went and sanitized it. They want you to give a phone number, and so, that's sanitized. Email address is there. If somebody wants to email me, they can, but, anyways. The demandant does not answer unknown phone calls. Send a text first. So, okay. So let's go to the next one. This is the memorandum, or the brief, I should say. Let's make it bigger so people can see it. Brief in support of demandant's motion to deny Texas Attorney General, motion to dismiss, and demandant's motion to strike. Comes now demandant moving the court to dismiss the Texas Attorney General's motion to dismiss, and moves this court to strike the Texas Attorney General motion for lack of standing. The demandant's a sovereign citizen. Continued. The Texas Attorney General is required to know that the Supreme Court of the United States has ruled that everyone and everything not privileged is sovereign. And this is Carlisle versus United States. The rights of sovereignty extend to all persons and things not privileged that are within the territory. So the question to be asked is, why is the Texas Attorney General not sovereign? Oh, I forgot. The Texas Attorney General is a government employee, and that's a privilege. Maybe that's why they have such hatred for the demandant, because they intend to enslave everybody. They hate anyone who thinks they have rights. And this is Yickwo versus Hopkins, for the very idea that one man may be compelled to hold his life or the means of living or any material right essential to the enjoyment of life at the mere will of another seems to be intolerable in any country where freedom prevails as being the essence of slavery itself. But beyond that, Will Livingston, who ratified the Constitution for the United States of America on behalf of New Jersey, 18 December 1787, is the demandant's fourth great uncle, which means the demandant is posterity as found in the preamble, and the demandant's entitled to right of blood, and no civil law can destroy right of blood, because all the laws of Congress and Texas are civil laws. And this is the maxim of law: the right of blood and kindred cannot be destroyed by any civil law. And this court is operating under power which is derived from the demandant as posterity, and the maxim says the power which is derived cannot be greater than that from which it is derived. And that's another maxim of law. Therefore, the demandant failed to give any of these wrongdoers or their bar member handlers or this court any authority over the demandant. And Justice Marshall, the Chief Judge of the Supreme Court of the United States, agreed and said it's impossible for the demandant to confer sovereignty which will extend over him. This is McCullough versus Maryland. So we'll just, the question is, but does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers are not given by the people of a single state. They're given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer sovereignty which will extend over them. And the demandant is exempt from these County of Montague thieves, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. That's Supreme Court, Kawanakawa versus Polyblank, U.S. Supreme Court, 1907. And the demandant requires this court to regulate their property under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or their property belonging to the United States, which is the supreme law of the land, anything in the constitutional laws of any state to the contrary notwithstanding. Article 4, Clause 2, or Article 6, Clause 2. And we, the people, failed to be U.S. citizens under the so-called 14th Amendment because it failed to exist when the Constitution was written. The term citizen of the United States must be understood to intend those who were citizens of a state. As such, after the Union had commenced and the several states had assumed their sovereignties. Before this period, there was no citizens of the United States. But there are actually two classes of citizens, because at the Revolution, the sovereignty devolved onto we the people, which the legislative inferior courts have affirmed. Dred Scott versus Sanford, Yickwo versus Hopkins, and this is Chisholm versus Georgia. At the Revolution, the sovereignty devolved onto the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects and have none to govern but themselves. The citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. And the courts have ruled that one can be a state citizen without being a U.S. citizen. And there's some court cases that talk about that. Both before and after the 14th Amendment to the federal Constitution, it has not been necessary for a person to be a citizen of the U.S. in order to be a citizen of the state. The Civil War martial law gave Congress, operating under executive authority, rise to some emergencies, which resulted in the current 13th, 14th, and 15th Amendments, and the 14th Amendment turned things on their head. And this is Colgate versus Harvey. And while the 14th Amendment does not create a national citizenship, it has the effect of making that citizenship paramount and dominant instead of derivative and dependent upon state citizenship. So, in other words, prior to the 14th Amendment, you had to be a state citizen before you could be a U.S. citizen. After the 14th Amendment, you could be a U.S. citizen without being a state citizen. And the 14th Amendment failed to affect the original citizens, state citizens. That there was a citizenship of the United States and a citizenship of the states, which were distinct from each other, depending on different characteristics and circumstances in the individual. That it was only privileges and immunities of citizens of the United States that were placed by the 14th Amendment under the protection of the federal Constitution, and that privileges and immunities of citizens of a state, whatever they might be, were not intended to have any additional protection by the paragraph in question, but they must rest for their security and protection where they have heretofore rested. And it continues to this day. This is Jones versus Temmer, 1993. Privileges and Immunities Clause of the 14th Amendment protects only those rights peculiar to being a citizen of the federal government. It does not protect those rights which relate to state citizenship. U.S. citizens are created by Congress and therefore Commerce Clause corporations. The term resident and citizen of the United States is distinguished from a citizen of one of the several states, and that the former is a special class of citizen created by Congress. And the term United States business means a United States citizen, which is why the legislative inferior Supreme Court has ruled that for U.S. citizens, the boundaries of the District of Columbia expand throughout the states of the Union. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens, even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company versus Tidewater Transfer Company, 1948. And there's actually a lot of court cases that talk about that. And in the Kavanaugh hearings, when he was appointed to the legislative inferior Supreme Court, he even said the government can go after a U.S. citizen in Afghanistan. Because U.S. citizens were created by Congress, they fail to have any rights not granted by Congress and are subject to the plenary power of Congress. Plenary jurisdiction, a court's full and absolute power over the subject matter and the parties in a case. It's a dictatorship. Plenary power is a dictatorship. Plenary is full, complete, entire. That's black's 8th, black 9th. Plenary power, complete power over a particular area with no limitations. This power is often refused to the commerce power of Congress. Under the Commerce Clause, Article 1, Section 8, Clause 3, Congress is granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. U.S. citizens do not have access to the first 8 amendments to the Constitution against the powers of the federal government, and that's Maxwell versus Dow. The privileged immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. The right of trial by jury in civil cases guaranteed by the 7th Amendment and the right to bear arms guaranteed by the 2nd Amendment have been distinctly held not to be privileged immunities of citizens of the United States guaranteed by the 14th Amendment against abridgment by the states. And in effect, the same decision was made in respect of guarantee against prosecution, except by indictment of a grand jury guaranteed in the 5th Amendment, and in respect of the right to be confronted with witnesses contained in the 6th Amendment. The term citizen in the United States is analogous to the term subject in the common law. The only absolute and unqualified right of a United States citizen is to residence within the territorial boundaries of the United States. State citizens are the only ones living under free government, and the County of Montague corporate thieves, or their Purdue, Brandon, Fielder, Collins, and Mott, LLP, bar member handlers, or the bar member bought and paid for clerks selling their just us in the inferior legislative 97th District Court, or the District of Columbia clerks masquerading as judges in this legislative inferior court, are incapable of impairing the demandant's right to own land or any of the demandant's rights in this matter. State citizens are the only ones living under free government whose rights are incapable of impairment by legislation or judicial decision. State citizenship is a vested substantial property right, and the state has no power to divest or impair these rights. In our country, the people are sovereign, and the government cannot sever its relationship to the people by taking away their citizenship. After saying all of that, it is true. The demandant is one of we the people and has all the rights of the king, the former sovereign, which means a sovereign citizen. But that does not mean that the demandant is not subject to law, because the demandant is still subject to common law, which in some cases is much more severe. And the Texas Attorney General is required to know all of this, which evidences their intent to take reprisals against the demandant for his political beliefs, perjure his oath to support the supreme law of the land, Constitution, which is authored by the demandant's ancestors, and Paxton and his hired bar member thugs are in dereliction of their duty to protect the demandant and we the people. And this is a Kentucky court case. It's true that at common law, the duty of the Attorney General is to represent the king, he being the embodiment of the state, but under the democratic form of government now prevailing, the people are king. So the Attorney General's duties are to that sovereign rather than to the machinery of government. So Paxton's perjured his oath. But instead, Paxton and his hired bar members are busy engaging in inflammatory language, calling the demandant a common citizen, when they are required to know it's true. The demandant has no problem with taxes because the government needs to be able to pay the bills. 2, but the government may only tax what it creates. But as the legislative inferior Supreme Court has said, all subjects over which the sovereign power of the state extends are objects of taxation, but those over which it does not extend are exempt from taxation. The sovereignty of state extends to everything which exists by its authority or is introduced by its permission, and the demandant cannot confer sovereignty which will extend over him. And that's in McCullough versus Maryland. And the demandant's rights existed long before the state was created, and the immunity of himself and his property from arrest or seizure except under a warrant of the law. And this is Hale versus Hinkle. The individual may stand upon his constitutional rights as a citizen. His rights are such as existed by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are a refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. The corporation is an artificial entity which owes its existence and charter powers to the state, but the individual's rights to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. And the demandant's right to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. And the demandant's rights to own land are further granted under Privilege Immunities Clause under Article 4, Section 2. The citizens of each state shall be entitled to privileges and immunities of citizens in the several state, which excludes corporations. Corporations are not authorized to bring suit under the Privilege Immunities Clause because it protects citizens, and the Supreme Court has held that corporations are not citizens within the meaning of the clause. The term, the Privileged Immunities Clause, has been interpreted not to protect corporations. Accordingly, Attorney General Frosch is entitled to summary judgment on the claims of plaintiffs' Paradise Point 1. To determine whether an activity is a right worthy of the protection of the Privileged Immunities Clause, it must be sufficiently basic to the livelihood of the nation that it constitutes a fundamental right. Including among these rights are the right to own and dispose of property, the right to access the courts of the state, and the right to pursue common calling within the state. From the earliest interpretation of the Privileged Immunities Clause, it has been established that the right to ownership of privately held property is a fundamental right protected by this provision. The states may not interfere with the right of a citizen of one state to take, hold, and dispose of property, either real or personal, which is why they are assaulting the demandant with their minor estate. And this is Title 31 of the Code of Federal Regulations. Entity means any owner of a Treasury direct account that's not an individual. Entity is a sole proprietorship, partnership, corporation, limited liability company, or professional limited liability company. Trust, the estate of a decedent, or the estate of a living person, such as an incompetent or a minor. Minor means an individual under the age of 18 years. The term minor is also used to refer to an individual who's attained the age of 18 years but has not yet taken control of the securities contained in his or her minor account. Because the term minor is also used to refer to an individual who's attained the age of 18 years but has not yet taken control of the securities contained in his or her minor account, is an entity which is the estate of a living person such as an incompetent or a minor, and therefore under the Commerce Clause, Article 1, Section 8, Clause 3, which was first brought into America with the Code of Law for the District of Columbia at 31 Stat 1432, where it says the legal estate to be the Cestui Jus, which was created by the Vatican by the Cestui V Act of 1666 for land titles. Yet still it is found difficult to set bounds to ecclesiastical ingenuity, for when they were driven all of all their former holds, they devised a new method of conveyance by which lands were granted, not to themselves directly, but to nominal fiefs, to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profit, while a season of the land remained in a nominal fief, who was held by the courts of equity, then under the direction of the clergy, it's still under the direction of the clergy, to be bound in conscience to account to a Cestui Jus for the rents and emoluments of the estate. That's taxes, and it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. After Congress passed the act that precipitated all of this, August 15, 1861, at 12 Stat 292, the Texas legislature passed an act defining what money and property is subject to taxation or exemption, and the mode of listing the same on August 21, 1876. Section 1. Being enacted by the legislature of the state of Texas, that all real and personal property in the state, the property of corporations, new, existing, or may hereafter created, and the property of all banks and banking companies now existing or may hereafter created, and all the bankers, except such as is hereunder expressly exempted, is subject to taxation, and such property or the value thereof shall be entered in a list of taxable property for that purpose and a manner prescribed by this act. And Section 4 defines person as a firm, company, or corporation. Section 4, the term person, whenever need in this act or any act regulating the assessment and collection of taxes, shall be construed to include firm, company, or corporation, further evidencing their intent to assault the demandant with their minor estate and evidencing Paxton's intent to be their accomplice. And this inferior legislative court is required to provide to the demandant a Republican form of government, Article 4, Section 4, Constitution, and as one of we the people, the demandant is a state in this union because we the people are the state. And the demandant has immunity against these County of Montague corporate thieves under Article 11 and Amendment. The government is but an agency of the state being the sovereign people. A state does not owe its origin to the government of the United States. In the highest or any of its branches, it was in existence before it. It derives its authority from the same pure and sacred source as itself, the voluntary and deliberate choice of the people. And a Republican form of government fails to include the District of Columbia Commerce Clause under Article 1, Section 8, Clause 3, because of Article 1, Section 8, Clause 17, to exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square. The demandant lacks standing against Hecht, and so this is paragraph 2. And these are all of the other issues that they brought up. The number 2 was the demandant lacks standing. Hecht has sovereign immunity under the 11th Amendment. Hecht has judicial immunity. Hecht has qualified immunity. Failure to state a claim upon which relief can be granted. And all of those are dealt with this now. The state of Texas is a subsidiary municipal corporation to the United States, which is domiciled in the District of Columbia. It's impossible for the United States of America or the corporation established by Congress called United States to engage in treason against the demandant, since Will Livingston, who ratified the Constitution for New Jersey, is the demandant's fourth great uncle, as previously described herein. The corporation set up in 1871 for the District of Columbia, called United States at 16 Stat 419, also at 28 U.S.C. 3215, is a parent corporation of the state of Texas Municipal Corporation and fails to have a shred of immunity in Section 1 as follows. That all that part of the territory of the United States included within the limits of the District of Columbia be, and the same is hereby created into a government by the name of the District of Columbia, by which name it is hereby constituted a body corporate for municipal purposes, and may contract and be contracted with, sue and be sued, plead and be pleaded, and have seal and exercise all of the powers of a municipal corporation not inconsistent with the Constitution and laws of the United States and the provision of this act. Because under the original act of 1871, it can sue and be sued, plead and be pleaded, which also means that all of its subsidiaries and other entities created under it can also sue and be sued. The codes passed by the state of Texas require that the Supreme Court regulate the State Bar of Texas and appoints 5 members, judges, to the State Commission on Judicial Conduct, and the State Bar appointing 2 bar members and 6 laymen appointed by the governor a bar member, and Hecht is chief judge. And the president and directors of any corporation are responsible for the acts of any corporation. And this is Rundle versus Delaware. My opinion has long been that the mayor and aldermen of a city corporation or the president and directors of a bank or the president and directors of a railroad company or other similar corporations are the true parties that sue and are sued as trustees and representatives of the constantly changing stockholders. A corporation, therefore, being not a natural person but a mere creature of the mind, invisible and intangible, cannot be a citizen of a state or the United States and cannot fall within the terms or the powers of the above-mentioned article, and can therefore neither plead nor be pleaded in the courts of the United States. And so he is responsible, the president and directors of a bank or a municipal corporation. Therefore, Hecht is the responsible party, and the demandant does not believe at this time that the associate judges of the Supreme Court are involved. There is an emerging dictatorship in Texas, and these bar members who make false statements in court assault you with the Commerce Clause under Article 1, Section 8, Clause 3, in violation of Article 1, Section 8, Clause 17, and if you object to it, they refuse to do anything about it. Under the Commerce Clause, it is a plenary jurisdiction, and that's National Mutual Insurance Company versus Tidewater Transfer Company, with no common law rights. The War of Independence was fought over taxation without representation, and now these District of Columbia bar members using the Commerce Clause to bring the District of Columbia outside 10 miles square, a maximum of 10 miles square, in violation of Article 1, Section 8, Clause 17, to represent the demandant by force and make false legal determinations for the demandant that the demandant's a minor estate, the demandant's an imbecile, the demandant's a taxpayer, and the demandant's their slave. So then they can tax the demandant. And this is if it were true that according to the spirit of our Constitution, the power of taxation must be limited to the right of representation. They have to represent you to tax you. Think about it. Whence it is derived the right to lay and collect duties, imposts, and taxes within this district. If the principles of liberty and of our Constitution forbid the raising of revenue from those who are not represented, do these not principles forbid the raising of it by duties, imposts, and excises by direct tax? So they forced represented me, and I got them. Anyways, and it is use it as justification for the theft of the demandant's land. Heck's bar member buddies are systematically selling people into slavery with their quasi-contracts. Assumpsit, at its origin, an action of tort, Assumpsit was soon transformed into an action of contract, becoming afterwards a remedy where there is neither tort nor contract, based at first only upon an express promise. It was afterwards supported upon an implied promise and even upon a fictitious promise. Introduced by a special manifestation of the action on the case, it soon acquired the dignity of a distinct form of action, which superseded debt, became concurrent with account. These are all commercial terms. With case upon a bailment, a warranty, bills of exchange, and competed with equity in the case of essentially equitable quasi-contracts growing out of the principle of unjust enrichment. And that's Black's Law Dictionary, 8th edition. Both in Roman and English law, there were certain obligations which were not in truth contractual, but which the law treats as if they were. They are contractual in law, but not in fact, being the subject matter of the fictitious expansion of the sphere of contract to cover obligations which do not in reality fall within it, which requires the minor estate, U.S. citizen, or other fiction. Constructive quasi-contracts are based solely upon the legal fiction or fiction of law. So they can assault you with a quasi-contract for their penal action. The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture to be forfeited for non-compliance with an agreement. The words forfeit and penalty are substantially synonymous. A penal action is a civil suit brought for recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. Such actions are civil actions on the one hand, closely related to criminal prosecutions, on the other to actions for private injuries in which the party aggrieved by statute may recover punitive damages. So, I mean, has anybody heard of, they call it quasi-criminal, okay? That's a quasi-contract. If you nail them down about the nature of the jurisdiction, they'll say it's quasi-criminal. Well, they're telling you it's a quasi-contract. And so I've heard of people actually going in there and saying, I plead non-assumpsit. In other words, I'm not going to play your game. I don't interested in your contract. And they're doing it in such a way that most of the people in there don't have a clue about what's being said, but the judge knows, I guarantee you. And the case disappears. A penal action is an action on a penal statute for recovery or penalty given by statute. Where an action is founded entirely upon a statute and the only object of it is to recover a penalty or forfeiture, such action is a penal action, which is why they use capitis diminutio. Capitis diminutio is the destruction of the caput or legal personality. Capitis diminutio, so to speak, wipes out the former individual and puts a new one in his place. And between the old and new individual, there is, legally speaking, nothing in common. A juristic personality may be thus destroyed in one of three ways: by loss of status libertatis. This is capitis diminutio maxima. By loss of status civitatis, this is capitis diminutio media, and by severance from the agnatic family, this entails capitis diminutio minima. And this is taken from the Institute's the textbook of the History and System of Roman Private Law. and capitis diminutio maxima, meaning the maximum loss of status through the use of capitalization. The high and most comprehensive loss of status, John Doe in all block capital letters, or Joe Doe John in all block capital letters. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. It swept away all the rights of citizenship and all family rights, all rights of blood. Think about it. And so the maximum of law says no civil law can violate right of blood. Black's Law Dictionary, 4th edition, because capitis diminutio maxima is used when they enslave you, using fraud and deception to sell you into slavery as collateral for their minor estate. He, the prisoner, has a consequence of his crime, not only forfeit his liberty, but all his personal rights, except those which the law and its humanity has poured him. He is, for the time being, a slave of the state. And that's a Supreme Court case, 1871. No, it's not Supreme Court, it's a Virginia case. Which are non-judicial proceedings, because whenever a statute's involved, the fake judge is actually a bought and paid for a clerk masquerading as a judge. It's the accepted rule, not only in state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes as a ministerial clerk for the agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency, which is why it's a bill of pains and penalties, and unconstitutional. Also means they have no authority to do anything. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. But the reality is they do it all the time, and they did it in this case. This is the tyranny that precipitated the causes and necessities for taking up arms. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits, depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter, do we saw the misery to which such despotism would reduce us. Despotism's dictatorship, folks. And so, remember, it supersedes common law. You can't argue both. You got to just argue one. That's why I don't ever tell them I want the stuff in that minor estate. I tell them I want it dissolved and liquidated, and I don't care what you do with the fake money in there. You can put it up your rectal orifice. And because otherwise, equity, you have to have clean hands if you want equity to give you a remedy. Tyranny is the exercise of power beyond right, which nobody can have, and the Declaration of Independence, 1776. Tyranny is the exercise of power which nobody can have a right to, and this is making use of the power anyone has in his hands, not for the good of those who are under it, but his own private, separate advantage. When the governor, however entitled, makes not the law, but his will the rule, and his commands and actions are not directed to the preservation of the properties of his people, but to the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion. 'Tis a mistake to think this fault only in monarchies. Other forms of government are liable to it as well as that. For wherever the power that is put in any hands for the government of the people and the preservation of their properties is applied to other ends and made use of to impoverish, harass, or subdue them to the irregular and arbitrary and irregular commands of those who have it, there it presently becomes tyranny, whether those that use it are one or many. And that's John Locke, Two Treatises of Government, Book 2, Chapter 18, Section 199 and Section 201. The demandant has filed bar grievances with the State Bar of Texas against more than 94 different bar members, some more than once, with evidence of felonies, and they were all dismissed as an inquiry. When appealed to the Board of Disciplinary Appeals, they were dismissed again. The demandants filed dozens of judicial complaints with the State Commission on Judicial Conduct, and all were dismissed, 25 on the same day. Heck is where the buck stops for all of us. Hecht and his bar member buddies are busy populating the prisons by assaulting people with the minor estates so they can collect royalties for orders of commitment and transcripts and others, in addition to their salaries, making it so that most judges retire millionaires with the royalties they pillage from the Treasury Direct minor estate accounts. There are more people in Texas prisons as a percentage of the population than there is in any other state of the Union, more than in communist China and more than in the Soviet Union. The Innocent Project estimates that 60% of the people in prison are innocent. There is no justice in Texas. There's just bar members selling people into slavery. If we were a Christian nation, they would be put to death. And this is Deuteronomy 24:7. If a man be found stealing any of his brethren of the children of Israel, and maketh merchandise of him, or selleth him, then that thief shall die, and thou shalt put evil away from among you. Hecht has ceased to represent the government and is operating in his private capacity. Paxton has failed to have standing to represent Hecht because he's being sued in his private capacity only. Paxton is an accomplice to Hecht and is misappropriating public funds. Requirement. Demand it requires this court to deny the Texas Attorney General's motion to dismiss and have it stricken from the record because they're not representing Nathan Hecht, and Nathan Hecht is required to hire his own attorney. Respectfully submitted, signed and sealed, red ink under penalties of perjury. I do everything under penalties of perjury, and they know that it's unreserved seriousness, basically. 28 U.S.C. 1746-1 means it's not in the United States. And then I, natural man, living in the Republic, do declare I've scribed and read the foregoing facts in accordance with my best first-hand knowledge. Such are true, correct, complete, not misleading, the truth, the whole truth, and nothing but the truth before God, angels, and everyone who reads this document as witnesses and pursuant to your rules of evidence, their rules of evidence. Dated this day of December 2024. So I'm going to be filing this on Monday, and I didn't quite have it ready to file in time. And then there's a certificate of service. I filed a similar one against the U.S. attorney, and I never heard a peep, not a peep out of him. I would not be surprised to see that U.S. attorney disappear. And if the U.S. attorney does ever respond again, it'll be a different one, I'll bet you. Anyways, I guess we'll see. I bet you what'll happen is that U.S. attorney will send a letter saying I've been replaced by another attorney. I've been transferred to another department. I've had that happen. They'll say I've been transferred to another department. Anyways, so the point is, oh, damn. You guys haven't been seeing that, have you?
Everyone's seeing what? Yeah, we're seeing it.
No, you're not seeing that one. Damn. That's it right here. You saw the first one.
Yeah, you posted that last week, right?
No, I didn't. No, I just got finished making this one up here today. I can post it, though. I can post it.
Please do.
Okay. Anyways, yeah. The reason I knew is because on the brief, the only thing you can have in the footer is a page number. Okay. You cannot have anything else. And so I knew that you hadn't seen it because on the brief, you notice there's just a page number. You're not allowed to, under the rules, under the local rules. But so I'll upload it to Telegram right now. Does anybody have any questions?
What is this case for? What transpired this?
What do you mean? What transpired? What do you mean?
What was the offense that sets you off on this?
Well, they stole my land. They stole my land. They were getting ready to sell it on me here 1st of September. And so about the middle of August, I filed a lawsuit against them. And I think I got them. quite frankly. I think they're done. I wouldn't be surprised to see the FBI go out there and do a raid, and a bunch of arrests be made. Yeah, for sure. And I'll bet you there's a shakeup in the FBI. Maybe there already has happened. I don't know. They never tell me anything. Matter of fact, let's go see who's listed as the special agent in charge of the FBI.
So they had it up for auction on the 26th of October, did they not?
Oh, they had it on the 1st of September.
Oh, 1st of September. You had a helpful judge.
Sorry?
You had a helpful judge that was giving you extra time.
No. What happened is he hasn't dismissed it. So I think it's because I'm bringing up valid arguments. If they don't dismiss it, I'll tell you, I've had enough cases in the courts that they get dismissed pretty quick if they don't think that it's something that they can do, or is something that I'm in the wrong court, or who knows what. You know what I mean? They dismiss it pretty fast. This case, I mean, I filed it in the middle of August, and they were going to sell my land. I actually had to go on the 1st of September, and I paid them a bunch of extortion, and now I'm going to break it off in their ass. We'll see. That's all I can say. You don't know until it actually happens. But I think that I'm definitely gonna. I think I got them, quite frankly. You saw the arguments that I was making, and they can't. There's nothing they can say to that. And so that's why I say I think they're screwed. So the judge wants me to call him up and ask for permission to file my second amended demand for relief. And so I got to call him up, and so I'm curious to see what they say. I'm probably going to do that next week. And I got to call all the lawyers up and tell them that I need to know whether they'll approve it or disapprove it. And they'll probably want the Word file. They'll probably I'm not sure. Yeah, I'll probably, I guess we'll see what they want. But so we'll see, they're going to have a problem. I want to add in the State Commission on Judicial Conduct. I want to add in the Board of Disciplinary Appeals, and I want to add in the Texas House of Representatives Committee on the Judiciary, and so all of them. So we'll see. That's all I can say. You just don't know how it's all going to work out. Sometimes there's things that you get waylaid or something, But so far, the judge has been babysitting me. He's been, like, for example, he wanted me. He said I had to file it because it's my second one. I get the first one for free, but the second one I have to get the lawyers, all of the respondents have to agree to it, or I have to get leave of the court. And so what I did is I filed a motion to file a second amended demand for relief, and he said you didn't have a certificate of conference, so I filed a one-page certificate of conference saying there was no conference. Anyways, he dismissed it, and he said that the one-page certificate of conference is not what he needs. He needs a certificate saying that which lawyers accept it and which lawyers do not accept it, and then he'll consider the second amended demand for relief as a leave of the court. And so we'll see. That's all I can say. we'll see. That's all I can say. I think I
How
uploaded
can you get in touch with them? How are you going to get in touch with them all this?
all of their paperwork has their phone number on it. So I'll have to call them. So there's 2 Texas state attorneys, there's a U.S. attorney, and there's 2 Purdue, Brandon, Fielder, Collins, and Mott attorneys. So I got to call like 5 people up. That's the only ones that have showed up so far, and ask them if they're if they have any objections to me filing a second amended demand for relief. Is basically what I got to ask them, and then they're probably going to want me to send the Word file to them, and so we'll see. I'll tell them why I'm filing it, and see what they say. It's probably, I can just about guarantee you that they're going to want to settle it. I'll bet you. We'll see. That's all I can. Sorry?
Are you going to settle, or are you going to bring a strike against them so it's permanent?
Well, I'm telling them. It depends on what the offer is. Everything's negotiable, of course. I want their bar cards. These lawyers, it just wouldn't have happened. I mean, it's going to cost them a hell of a pile of money if they want me to settle it. And I don't know how I can do anything about the common law court decision. I mean, the common law court decisions, that's a done deal. There's nothing I can do about that. But as far as how much money they give me, my attitude is that they caused this. I mean, it's going to cost, the common law court decisions for a bill. And so, I don't know. I guess we'll see, if they want to settle, we'll have to see. But, hey, it's all negotiable.
Then their insurance goes up. They won't be able to, do this again. They'll never serve in public ever again if you really push it.
Well, that's why I want their bar cards. The lawyers, especially there's one lawyer in particular, I want her bar card, and she's the one that really did it. I want the judge. I want those judges done off of the bench. I want them out of there. And I want the lawyers' bar cards, at least some of them. There's one in particular. Actually, the 4 of them. There was 4 lawyers that brought that action, so I want all 4 of them. I want their bar cards, and I want that judge. I want her gone, and so we'll see. It depends on what they're going to offer. We'll see. That's all I can say. I want the state bar. If people object to them assaulting them with the Commerce Clause, they have to put a stop to it. You know what I mean? And especially if people object and they're selling people into slavery based on these quasi-contracts, and the Texas prisons are full of people that have been enslaved. And there's a friend of mine that he was attacked because of a seatbelt, and he got 30 years in jail for attempted murder, and that's a bunch of crap. And so I got half of mine to include him in that. Basically, I want him out of there. And, he's been in jail for over 10 years. I think that he should get a major settlement. Anyways, yeah, don't get me going. You're going to get me going now. So we'll see. Again, it's negotiable. We'll see what they have to say about it.
Okay, you said you're going to post this. Is this on the main wall, or is this in your group room?
This is in my I uploaded it to my group room. Glenn Fern. If you go to my group room, I uploaded the brief and the response to the motion to dismiss. They're both uploaded in my room. And last week, let's see, what did I upload last week? Oh, hold it now. I'm on the wrong place. No, I was right. That was me. Let's make sure I'm at the right place. Oh, I did upload it. I didn't upload it to my group. I uploaded it to Lori's Telegram. Okay, I'll upload it again. Okay, and then what did I upload? There's a motion for leave to demand relief. Yeah, I uploaded that last week, and then I had those court cases about privileged immunities clause. That's a self-executing clause.
Where did you source that from originally?
Actually, a guy put that on my group. Veritas Ghost, one of the members on my group, puts a lot of cases and stuff. But it's listed, the cases where you can look it up are there. You can go ahead and look them up yourself if you want. I'm not sure if I've uploaded my second amended demand for relief, so I could upload that to the Word file. The document itself is quite large, and so, but I can do the second amended. But that hasn't been, it got struck because I didn't get leave to file it yet. Still working on it. I still might get it filed. But this is the second amended demand for relief that I'm uploading now. And it's called a second amended counterclaim, but it's actually a demand for relief. I just didn't change the name of the file that much. But so anyways, but that'll give you an idea on the arguments that are in there about the courts, about bills of attainder. I mean, this is all bills of attainder and bills of pains and penalties. And lawyers, bar members, and how there's a emerging dictatorship with the bar, with these bar members and everything. And so that's why I'm doing this, because it's an emerging dictatorship. So anyways, does anybody have any other questions? It's got to be getting late.
Yeah, so what I understood of what you said was basically you don't worry about anything that the QSIP numbers are generating. You just have to basically give back to Caesar's what's Caesar's, or what did you say?
I don't use those kinds of words. I don't use those kinds of words. If you remember that remember that cause and necessities for taking up arms site that I just read, it says that it supersedes and replaces common law. So two things I would state when you're using those kinds of words is, first one is caveat emptor, okay? Buyer beware, okay? You're getting yourself in a contract with the devil, really, is what's happening. That's the first one. The second one I'd say is clean hands. Under the clean hands doctrine, you cannot claim fraud if you participate in the fraud. And when you're doing that stuff, you're participating in the fraud. You cannot make a claim against any of that stuff without participating in the fraud. So I do not go there. I do not use those kinds of words, and I stay away from that stuff because I want to be able to have put them in the position that they have to. That's why I told them that I don't care what you do with the fake money in it. You can put it up your rectal orifice. They'll probably have to give it to me, but I really don't care. I want the damn thing dissolved and liquidated. And, that's the bottom line. And I don't care what they do with it.
Hey, I actually agree with that. That's why, yeah, I agree with that. That's why I did a default judgment and so on. Thanks for sharing.
Yeah, but if you do anything to claim any of that stuff, you're participating in the fraud.
What do you mean, like the interest that was being generated off the QSIP numbers, right?
Yeah, let's participate in the fraud.
Agree. I agree.
So my attitude is that it's a fraud, it's a nullity. I want nothing to do with it. I don't care about anything related to that. The fake money, I call it fake money, and you can put it up your rectal orifice for all I care. Whatever it's in there, I don't really care. I just want it dissolved and liquidated, and that's where I go with it. So I don't, like, there's a friend of mine that just used a 1099A to buy a $70,000 car. And he told me how he did it. And, I wish him the best of luck. I hope it works out. He hasn't taken possession of the car yet because he's got to wait for the IRS to send the money to the dealership. But I hope it works. And if it does, well, you never know. I might try and do it. But it's all a separate thing. And I would never, ever put something in the courts, any of that stuff. And anytime I'm in the courts, I never, ever talk about that. I don't use those words. I stay away from those words. And except that I'm telling them that they're assaulting me with that minor estate and to put me under the Commerce Clause where I don't have any rights. And I am the king. I'm entitled to all common law rights. And there's no contract that they can say that I'm involved in because that's called treason if they try something like that. And so, and they know it. And so, again, any contract has to be knowing, willing, and intentional. And I tell them that too. There's no knowing, willing, intentional contract. What I did with these Montague County thieves is I sent them a notice and demand in 2021. And I said, I want to see a bona fide contract by which I've agreed to this. And these are the list a bunch of felonies that you're involved in, and either produce a contract or you're guilty of all these felonies. And crickets. They never said anything. So that's why I think I got them. I'll bet you I got some of them in jail. And we'll see. That's all I can say. But I think that with Trump coming in, I think that since Trump ran in 2020, things started changing. I'm hearing that Gorsuch is busting their balls, and I hope he is. And I hope that we're going to start getting lawful courts where there's real justice. I hope, I don't want, and that's one of the things I say in my documents, is that these communists are trying to make us lose confidence in our institutions, and that's part of their agenda. And so we have to fight against that, and we got to have, justice and honor and truth and things like that. And I think that it's coming around. It's coming that way, but it's things like that. The ship of state is a big ship, and it takes a long time and a lot of effort to move that ship. And but that's why I tell them that I'm the king, and you work for me. And I put them in a position that I didn't give you any rights to do anything, and you don't have and my right to own land cannot be injured by you or them or anybody else. And the courts have been very vociferous about that too. So, anyways, if nobody's got anything else, it's getting kind of late. I know on the East Coast it's 12:30.
Well, before you came on tonight, there were some really smart people asking what they would, if they had the opportunity to ask Trump one question, what it would be. And there was some really great questions in there. One of them was they would ask him about the UCC that he wrote to, I guess, get himself out of a lot of trouble there when they were trying to indict him. But that would be a very interesting question, eh? To ask Trump about the UCC he wrote.
I think I've got something from Trump that was sent to somebody, but I'm not sure where it is. But I know I saw something that was a letter from Trump that basically it wasn't a but it was something that it was when he was a president. It was something that he wrote. Let's see if I see that anywhere obvious.
I'm sure it was a UCC and not a non-UCC. Just asking.
Breaking up.
Are you sure it was a UCC and not a non-UCC?
It was a non-UCC. It was a non-UCC.
Okay, that's what I thought. Because a non-UCC would make sense. A UCC, not so much. Because a UCC would put him right in their jurisdiction. He was taking himself out of their jurisdiction with a non-UCC. And by the way, you don't do 1099A purchase things.
Well, this friend of mine did that. I didn't do it, and I'm not exactly sure. I've heard a lot of theories about that stuff, and he told me how he did it, all the procedures, everything. Matter of fact, what he did is he got the dealership to fill it out. And
I bet they did, because what happens when you do a 1099A is it issues 2 1099 OIDs to the trustees. So now they get to collect on it. But it doesn't mean that they have to hand over any property.
No, not until they get paid. He told them they could just keep the vehicle until the check comes in, and he said, "Just call me when the check comes in."
They're getting that in the check, and the checks are the 2 1099 OIDs because they're acting as trustee, especially if they filled it out. Yeah, they're collecting on it, but he's not going to get the property either because it's gambling. That's what a 1099A is. You're wagering. That's what the loan part is. If you put a loan amount to be equal to the fair market value, then you're saying it's going to keep that value, right? If you make it less, the fair market value less than the loan amount, you're doing a short. You're saying that it's going to depreciate in value. The only way to actually, quote unquote, fund it properly is the fair market value has to be more than the loan amount. But even then, it's issuing 2 1099 OIDs to the trustees, creating bad debt. You don't do that for a transfer of title or a transfer of the asset. If you're going to acquire the asset, you use an asset acquisition form because that's for asset acquisition. That's very literal. That's an 8594.
I have no idea. I'm not the one that did it. And he told me how he did it, but I didn't pay any attention because I have no plans to do it. If it works, if I see him driving around in that car, then I will go to him and we'll talk more. But until then, I'm in the wait and see mode, and so I have no idea. I don't know anything about the theory. I'm busy with my lawsuit. I have other things to worry about. I don't have time to worry about everybody's what I call unproven theories. And so I appreciate your comments, but I have no idea. And it's not something that I'm particularly interested in until I see results. And so we'll see. He's a friend. I don't wish him any ill will. I hope that it works out for him. So we'll see. That's all I can say. I appreciate
If he
your comment.
wants it to work, he needs to do the transfer the title with the 1099-S and then asset, ledger the asset with the 8949. That's the invoice that's supposed to go with every single 1099. And then,
I have no idea. He talked. What he did is he went and talked to the CEO, not the CEO, the chief financial officer for the company, for a dealership, and told him what he wanted to do. And the chief financial officer says, "Okay, well, we can try it." This guy is a CEO of a corporation of a fairly large. They have 300 employees, and so he's a pretty smart guy, and he knows how to talk to like these people, like chief financial officers and that. Anyways, so they went and they said, he talked to his finance department, and they figured out how to do it. And so, I don't know. Beyond that, I have no idea. And I hope it works out. I guess we'll see. But I have no idea. It's not something that I'm particularly interested in. It's not something that I really want to have on my channel where I'm talking about law, because that's really not law. That's private contracts is what that is. And, but it's well established there is a minor estate and it's got money in it, and that's what he's accessing, is that money in that account, in that Treasury Direct account. And so at any rate,
okay. Contracts are law. That's what law is. But yeah, I was just letting you know one way to do it.
I appreciate the comments, and yeah, good idea. You muted yourself. Anyways,
Hey Glenn,
yeah,
I wanted to tell you, she said she also did it before, actually. I think she just jumped off, but yeah, she's done the the 1099A, so she just basically tell you, the method of it,
well,
basically.
it's not anything I'm interested in, and it's not anything that's the topic of my channel. I stay away from that stuff. I consider it unproven theories, and until I can see results, it's not something that I'm interested in, and it's not. And I have other things that I'm focused on, like keeping like law where they're stealing my land, and I'm not interested in discharging that debt. That's rewarding them. If I probably could have figured out some way to discharge that debt using that minor estate, but that's rewarding them. They're going to do it again. And now what's going to happen is if maybe, I don't know, we'll see, but maybe there'll be a big decision where all sorts of people get the benefit of law because this doesn't apply to most people. The property taxes, it applies to corporations. And so we'll see. I don't know what's going to happen. But I think I got them. I really do. And it's using law. It's not commerce. And so I like to stick with law. I never bring commerce into court. And if you again, I'm not interested in doing that. There's a place for everything, and I don't think the courts is a place for commerce, although they do it. But again, it's because we don't know the law. And but I appreciate your comments. And I think that's about it for me for tonight. Thanks for everything. And it's getting kind of late anyways. I know it's late here. It's got to be an hour later on the East Coast. And so you guys have a good weekend and have a nice Christmas.
Yes. Thank you for showing up tonight, Glenn. And happy holidays. And I hope you get to enjoy lots of downtime and, kick back and not think about all this workload that we always think about 24/7. At least take a couple of days off.
That's right.
And we'll talk next Friday, right?
Yeah, I'll be here
I
next
just
Friday.
want to tell Glenn one thing before he. My apologies. I just wanted to tell you that I agree with what you're saying. So I actually haven't filed taxes for years, and I also am waiting, just like you, for a lawsuit. I have a default judgment against 9 judges and a bunch of clerks and district attorney and so on. So yeah, I honestly didn't believe you know, filing taxes and stuff like that anymore. I know that that pulls you into their jurisdictions, but what I just found out was basically we're not filing taxes, we're reporting the taxes. You know, the fraud that's going on, and of course because they get in their interests and stuff like that. So yeah, I just felt like I just had to share that with you. I am waiting for my caveat payout right now. Um, yeah, and it's definitely on 16 people.
Okay.
All of them are in.
Okay. Well, thanks for everything, everybody. And we'll see you next week. Same time, same place, same channel.
Okay, thanks, Glenn. Take care. I'll send you the
Good
recording.
night. Thank you for being here.
Thank you.
Okay.
Take care. Bye.
Smith, thank you.
Yeah.
I sent you a oops.